He's a crook, right? Yeah, he's crooked. Now, did we also mention he happens to be a lawyer? Do you think, and another piece of trivia for you, his work that he charged the attorney fees was for getting a land patent for the land that he ultimately ended up selling because his client didn't pay his attorney fees. So he knew that there was an asset because he helped them get the asset. All right, next case, Harris versus Balk. Oh, we've already got a volunteer. Mr. Cockerham's hand up went first.
Yeah, this is a 1905 Supreme Court case in which the cause of action deals with something called attachment jurisdiction. The rule of law states that a judgment of garnishment, which is what this case dealt with, or attachment against a debt that is handed down in one state is entitled to full faith and credit when the parties to the debt are residents of another state. There's really three different individuals involved in this case, so you got to kind of follow the connections. Balk is the plaintiff. He's a resident of North Carolina, and he owed $344 to a Maryland resident named Epstein. Harris, the defendant, was also a resident of North Carolina and owed Balk $180. While Harris was traveling to Baltimore, Maryland, he was served with a writ of attachment from Epstein for the debt that he owed Balk, $180. After returning to North Carolina, Harris consented to the attachment, but shortly after this consent, Balk sued Harris in North Carolina for his original $180. Harris argued that he had already paid the debt in Maryland, and that judgment was entitled to full faith and credit by North Carolina courts. Procedurally, the North Carolina state courts held for Balk, finding that the judgment was not entitled to full faith and credit, given that Harris is only temporarily in Maryland, not a state resident. The Supreme Court granted cert for review on the issue of whether a judgment of attachment that is made in one state is entitled to full faith and credit in other states. The holding was yes. In this case, the subject matter was a garnishment, which is a product of state law. For that reason, so long as the plaintiff has proper personal jurisdiction over a potential garnishee, a state law controls regardless of whether garnishment is proper or not. The full faith and credit in the Constitution states that a final valid judgment for one state must be acknowledged and enforced in every other state. Therefore, the lower decision is reversed.
That's it. The people who print up these cheat notes say, does the situs of the debt travel with the debtor for jurisdictional purposes? And the answer is, when you have a final judgment, and because of the full faith and credit clause, yes, it has to. As long as they had subject matter jurisdiction, personal jurisdiction, and due process, it's valid everywhere. And so therefore, the debt that they got a final judgment on, you can enforce it in a different state. That's the situs, or the site of the debt, and it travels with the person that owes the money. Once you get a valid judgment, you can go anywhere that they run off to enforce the judgment. Thank you, Mr. Cockerham.
I have a question.
Yes, ma'am.
It said that as long as Balk knew about the judgment, what if he didn't know?
Well, that would have violated due process because of notice and an opportunity to be heard.
Okay, so who has the duty there to tell him?
The plaintiff, if the plaintiff's trying to get him into court, the plaintiff has the duty to tell him about the original judgment. And then you can take it and enforce it against anybody that has his property through a garnishment. Yes, Ms. Wills.
I have that Schaefer overruled Balk. So is that still good law?
It still is good law. Full faith and credit can't be overturned.
Okay, I was wrong.
They may have overturned it on a different point, but it's still entitled to be recognized in every state. All right, Pennington versus Fourth National Bank. Okay, go ahead.
Pennington sued Fourth National Bank to recover money paid to his ex-wife. They'd been divorced in Ohio, and he was ordered to pay alimony. At first, the bank didn't pay it because the court order told him not to pay the alimony. And when she sued, the bank ended up taking all the money out of his checking account. He said that he was denied his 14th Amendment right to due process because he wasn't a resident of Ohio. The court said that they had the appeals court, the trial court and the appeals court both said that they had the right to take the money, called the full faith and credit, and he appealed to the Supreme Court, and they affirmed it.
They did. The issue in here is an in rem proceeding. Does due process require jurisdiction over each party claiming title to the property? And in rem, no, it doesn't, because they can have exclusive jurisdiction over the thing, and that is the money in the account. Now, another critical point that's in your brief, and I don't remember if this was covered in your book. No, it's just mentioned in your book. Substituted service on a non-resident by publication furnishes no legal basis for judgment in personam. That's another one of the black letter law statements that comes out of this case.
You do that one more time.
But the Supreme Court ruled the court did have jurisdiction because the bank account was within the jurisdiction?
Yes,
Okay.
because the bank was in the jurisdiction. So they had jurisdiction in rem, but the other black letter out of here is that substituted service on a non-resident by publication. In other words, service by publication furnishes no legal basis for judgment in personam. And I just said that 5 minutes ago when we talked about Penoyer versus Neff. Publication never gives you in personam jurisdiction. Now, what does that mean so far? Well, what if I serve publication in Oregon through a newspaper called the Pacific Christian Monitor, and then I want to enforce that judgment in Washington because now the debtor is in Washington? Can I enforce it in Washington?
No, it's insufficient service process.
That is, it's insufficient service of process because publication never gives you personal jurisdiction. If you want something that's going to be enforced across state lines, you need in personam jurisdiction. This last case, if you only need it to be enforced inside the state, then you can go against the property, which is in rem, and you don't have to have personal jurisdiction. But you better have a judgment to start with that says that they owe the money for them to enforce that in rem action. Everybody got that? So of your three different types of jurisdiction, in personam, in rem, and quasi in rem, know that in personam, publication never gives you jurisdiction in personam. Does it give you jurisdiction in rem? Yes, it does. Ms. Gale.
And that jurisdiction in rem is only in state?
In state against the piece of property or thing that's actually in state. Yes, ma'am.
So if you don't get it in persona, like you have it in rem, like nowadays, you get the property back, but can you get your money since you can't see that person individually?
You're talking about kicking somebody out of an apartment and going in rem against the apartment to get possession and then trying to get back rent against
So
them?
you have to get it in persona to get the money. Right?
You got to get in personam to get the money. But you can have in rem
But I
only
have to go ahead and get my apartment back.
in rem. Yes, ma'am.
How does that work for divorces now?
We're getting to our divorce cases in a minute.
I know, but the 4-week consecutive thing in the newspaper, which printed.
Oh,
today,
it'll give you a divorce,
It will.
but it won't adjudicate any of your property rights because you don't have in personam jurisdiction. Property, including alimony, any other rights like child custody. You can't make any decisions on those in a published divorce.
But
So,
you could do the divorce.
but you can do the divorce. Now, I actually had an attorney call me up. This has probably been 5 or 10 years ago. He was having difficulty getting the defendant served in a divorce. And they had tried multiple times, and the judge went ahead and said, yeah, you can serve them by publication. And so the attorney called me up and said, hey, look, we've already published 2 weeks. We've only got 2 weeks more to go, and we're finished with our publication, but he's coming to town. What should I do?
Get that money.
Well, having a sense of humor, I said, well, it depends. Do you want to be able to determine alimony and child support and child custody? If you do, then you've got to get personal service. But if you don't want to determine any of those, just rest on your publication. Oh no, we've got kids, we've got to get child support. Then serve them while they're here in state. You see how easy this stuff is?
Yeah.
And there's an actual summary that we're going to do up on our board over here that shows you the better types of personal jurisdiction to keep them in court. We're going to organize them into 6 different categories of which is better and which is worse. And that's going to be part of the summary that y'all turn in next week. And then the other part of it is take the cases that you've actually read and tell me which one it falls under. And then that way you'll know, according to your chart, which one you have better service under. Because whichever one you have better service under, that's what you argue to the court. I've got this jurisdiction because of, but even if you don't find this, I've still got this one to back up on. And then you follow it further on down the chart is your weaker argument. All right, so substituted service never gives personal jurisdiction. And that actually is Penoyer versus Neff cited in this case. It's on page 283 of the opinion if anybody's looking for it. All right, who did Pennington? Okay, you got credit for Pennington.
Oh, is that all you're doing?
What?
Oh, what's next? Just jump in here. What's next?
Actually, we already have a volunteer for Grace versus
Now, where is
MacArthur.
this at? Who's doing this? How they doing? They're raising it. They say emails? What's going on? How do we sign up? Because I don't see anybody raising their hand. Oh, is that what? Help me then.
You have to just yell out, I'll do it.
I got it.
Well, the first hand I see fly up is the volunteer I take, and I see one right over here. He's kind of subtle. He's holding it up behind his wife's head so you can't see it. Okay, last name?
Correct.
Mr. Gray, go ahead.
Yes. The issue was there was a resident in Arkansas that was suing a company based in Illinois. MacArthur was a major stockholder. His representative was Mr. Smith. Mr. Smith was on an airplane going from Tennessee to Texas. When he was over Arkansas, he was service process was completed. The argument was that he was up in the air. He really wasn't in Arkansas. He was 30,000 feet above Pine Bluff. So therefore, service of process was insufficient. In addition, MacArthur had made several motions, his attorney, that there were several other different issues. But the big issue that the court chose to focus on was that plane in the jurisdiction of Arkansas and could he have been served? There are cases in Minnesota and New York to back it up. The question that was never asked that I thought was interesting was, well, sir, if you were above Arkansas 30,000 feet and you say you weren't in Arkansas, where were you? You know, that was never asked. So if he wasn't in Arkansas, what jurisdiction was he in? He had to be in some jurisdiction. And that was the argument that he was not there. The court did not see it that way. As evolution of transportation, if he had been in a covered wagon in 1875, he would have been validly served. If he was on the train in 1922, he would have been a valid service, and transportation has increased, and just like the drones that are coming about now, who knows, you might just go out front, get on one and fly to, Huntsville.
Speaking of drones, did y'all see the one drone that dropped the marijuana and the cell phone into the prison?
Yep.
Oh, yeah, they do that all the time.
And then he still couldn't catch it.
Yeah, he's
Yeah.
All right, so if you're in the airspace above a state, you are considered to be in that state. It's essential to the safety of sovereign states that they possess jurisdiction to control the airspace above their territories. The power extends to the exclusion from the air of all hostile persons or demonstrations, and to the regulation of passage through air of all persons in the interest of public welfare and safety. They cited a case with approval and said the sovereign power and jurisdiction of a state is not limited to the ground. An airplane in the air over the territory of the states within the state and subject to its sovereign power. That's pretty simple, right? Now, is there a point at which maybe above a state is not close enough to be within the jurisdiction of the state?
In the future.
It's what? Well, how far up can you go before you can say you're not in a state?
But doesn't
Irish drones.
the drones?
To where the military has
Like you
jurisdiction.
can fly
probably.
drones over someone's
Yeah.
property. You just can't fly
Depending
them
on
at
the
a
flight
certain
lanes,
elevation.
they got lanes, sky like highways, so probably once you go up and get the international flight line.
Yeah, but that's how they got them served is the airplane was over a particular path that went over the state, right?
I think I read somewhere 20 miles is
There's
the,
levels.
20 miles up is the limit.
But the
20 miles would be, hold on,
20 miles.
A little over
hold on,
100,000.
20 miles would be what, 100,000 feet?
Yeah.
That's not right.
That's what.
Technically, aren't you in space at that
That's
point?
what.
Yeah.
That's why they set the limit so high.
Cruise altitude is 40,000 feet, 35.
If you were arguing against jurisdiction of it, would you argue that, hey, there's no oxygen supply up there? You can't breathe up there, and therefore you can't be in the state if you can't breathe?
You ain't up there, so then it really doesn't matter.
Yeah, but you're in a pressurized airplane. It's a different story.
There was one guy that did a free fall from over 100,000 feet. Yeah. It was Red Bull. They had him go up on some sort of platform and he just did a free fall. He was in a pressurized suit though. All right. Let's see who did that one. Mr. Gray. All right, Milliken versus Meyer. See, she beat you. Her hand went up 4 years ago.
Yeah, I've already picked mine. I'm gonna wait till it's time. I think his family. I'm gonna wait till we get closer.
Okay, what's your last name?
McNeil.
Okay, Ms. McNeil, go ahead.
Okay, Meyer, who was a Wyoming resident, was served in Colorado for a claim brought before a Wyoming state court. Meyer refused to appear and his default judgment rendered against him. When Milliken, if I'm pronouncing it right, tried to enforce the order against Meyer in Colorado, Meyer resisted. So the issue was, did Wyoming have jurisdiction over the defendant? And the court says yes. The Colorado court found that Meyer was, how you say it, domicile and Wyoming when the Wyoming suit was commenced, and that the Wyoming statute for substitute service were constitutional, and that the affidavit for the construction service on Meyer was filed in good faith. So yeah, they had jurisdiction over it.
Okay. There's a few good quotes in here that you need to be familiar with. And one of them is at head note 6. Domicile in the state is alone sufficient to bring an absent defendant within the reach of the state's jurisdiction for purposes of personal judgment by means of appropriate substituted service. Substituted service in such cases has been quite uniformly upheld where the absent defendant was served at his usual place of abode in the state, as well as where he was personally served without the state. So if you're a resident of a state, you can be served either in a state or out of state. It doesn't matter. If you're a resident, you're going to be subject to that state's laws. period. If you're a resident, period, you're going to be subject to their laws. Also says, and it quotes another case we're about to cover, Blackmer versus U.S. It just says the state's authority over a resident doesn't terminate just because the resident's not here. Any questions about that? Yes, ma'am.
Oh, no, that's cheap.
No, that's.
That's Bodie.
All right, the next one is Goodyear Dunlop
Yeah,
tires.
that's me right here.
I saw a hand up here.
Can you write me down for that?
You skipped the baby case.
I think we're starting to act like lawyers.
I already had Jim, I think to file that first.
Wait, you skipped one.
Yeah, I know, I'm not necessarily going in order. Y'all got to wait till I call the case before you volunteer. Huh?
Right. Keep me in mind for that.
All right, Mississippi Band of Choctaw. I saw this one first. Last time?
I've been plotting.
I got you, Ms. Johnson.
So this is a case where there was a married couple and they were part of the Indian tribe, the Choctaw Indian tribe.
Girl sang a song about it.
By the way, I've actually quoted this case to a judge last week in court.
Oh, really?
Yeah, and it was kind of nice being able to stand there in front of the judge and say, Judge, this case is clearly controlled by Mississippi Band of Choctaw Indians versus Holyfield. And the judge looked at me.
I mean, how can they argue that? Like, if you played the case, you obviously know.
So go ahead.
Yeah, so this couple, married or whatever, lived on the Indian reservation, and they left, the woman was pregnant with twins, they left the reservation and went a couple hundred miles away and had the twins adopted out to the defendants, essentially, in the case. And the tribal court wanted to have the adoption vacated because they were saying that the Chancery Court didn't have jurisdiction over the twins. The defendants claimed, since the parents left the reservation, that they abandoned the twins, and so they, the jurisdiction was valid and the adoption was valid. So the Indian Child Welfare Act gives the tribal court exclusive jurisdiction over proceedings related to the children part of the Indian that are part of the Indian tribe and that are living or domiciled on the tribe reservation. They ended up they vacated the adoption because they said even though the children were born off the reservation, their parents were domiciled to the reservation and they did have jurisdiction.
Okay. Besides, if we strip out the Indian Child Welfare Act out of this opinion, here's the key things, and it starts off at headnote number 2. Domicile, of course, a concept widely used in both federal and state courts for jurisdiction and conflicts of law, and its meaning is generally uncontroverted. Domicile is not necessarily synonymous with residence. For adults, domicile is established by physical presence in a place in connection with certain state of mind concerning one's intent to remain there. That is what a domicile is. Is that the same thing as a residence?
No, they do that a lot in the military. You'll have people all over the place that they'll be from Florida or they'll be from there, and that's their state of residence or domicile.
That's their domicile, even though they reside somewhere else. All right, how many of y'all have got a condo at the beach?
Yeah, that's what I think about vacation.
Like own or rent?
Either one, where you go and stay relatively regular. How about place over at the lake? Now, is that your domicile or is that just a residence?
Resident.
That would be a domicile.
Wait, place over at the lake?
Is it a domicile?
No.
It's a domicile if you intend to permanently stay there, right?
Yeah.
Do you intend to permanently stay at the lake? When you retire, though.
Right.
So there's a dimension of timing in there as well. Do you intend to permanently be there until you retire. No, you plan to stay where you are, continue to work until you can retire. So although you've got 2 residences, only one of those is the one where you have the intent to return there and stay there permanently, and that's what your domicile is.
So you can only have one domicile at a time, right?
You can have one domicile,
Okay.
but you can have multiple residences. I saw a hand go up.
It would also be like college.
Oh, mine.
Oh, you're trying to get the next one. All right, there's another one, and it's called a domicile of origin. You acquire a domicile of origin at birth, and that domicile continues until a new one, a domicile of choice, is acquired. So let me tell you about the facts of this other case and see if you think that I was arguing right on point with Mississippi Band versus Holyfield. We have an open child welfare case here down in Jefferson County, and the mom's pregnant, but she doesn't tell anybody. She hides it quite well. She's going into delivery, so she drives to Huntsville to have the baby. Has the baby in Huntsville, and the child never leaves Madison County. But DHR here, because there's an open case here for siblings, files a case here saying the child needs to be picked up and put into foster care. Now there's a statute that says this is the proper place to file it if either the child lives here, is a resident here, or if the child is located here. Do we have either one of those?
Is there a time limit on that statute, in that statute? Or it has
No.
to be for like 3 months?
But isn't it based on the parents' domicile? Because she wasn't planning on staying in Huntsville.
Well, here's the thing. What's the child's domicile of birth? It's Huntsville, isn't it? And has the child changed their domicile? In fact, the mom took the child there with the intent that the child stay there with a relative, rather than bring the child back here where DHR was going to take the child away. So where do you think the case should have been heard? Should have been heard up in Huntsville, right? So standing there in front of the judge saying, Judge, Mississippi Band of Choctaw Indians versus Holyfield is clear on this point. The child is not a resident of Jefferson County. Never has been, and the intent is that the child never will be.
And I resided with the mother in Jefferson.
Yeah, was the mother not still domiciled in Jefferson County?
She is, but she went out of county to make sure that DHR here couldn't get her baby.
But
She is, but the child's not, right?
As a minor, he can't choose. A minor is a baby, he can't choose.
Yeah, but the mom chose for the child and said, you're not coming back to Jefferson County because they'll take you away. I'm leaving you here in Madison County. So what do you think the child's domicile is if the mother's intent was that the child would stay there?
So domicile has two things, intent and where police reside.
It has 2 things. Intent is key, and it also is location.
Okay.
You got to have the location with the intent to stay there, or a parent that has the intent that you not come back. Y'all got that?
Professor Bodie, I'm just confused on this point because I must have misunderstood the case when I read it. My understanding was that it was not altered by the voluntary surrender for adoption, that the domicile stayed with the children based on their natural mother's domicile.
Right, but the mother in this case is differentiated because the mother in the case up in Huntsville never wanted the child back there. This one, the mother took the child with the intent of adopting the child out, so the child was meant to stay with her until she could get the adoption. The other case was she never wanted the child to be here to start with. Never did. Yes, ma'am.
So if my children are with me 1 week in Madison County and 1 week with my husband in Morgan County, are they domiciled as those places 50% and 50%?
No, because there's an intervening court order, I would think.
In life. But they were born in Huntsville Hospital. So.
All right, any other questions? The key thing here is domicile. Domicile is both where you are located and where you intend on staying. Children acquire one where they're born. It's usually with the mother. Now, is that constitutional? Does it violate equal protection to give mother priority over the father? It does. You can't presume that the child is in the mother's custody. That's one mistake that the Supreme Court made, and that's easy enough to differentiate. But if it's a child born out of wedlock, I think that's probably still a good presumption that it's with the mother, because she's the only legal parent until the father signs the affidavit of paternity. That's getting way beyond civil procedure. All right, Goodyear. I see your hand first.
All right, guys.
Now you realize this is a tough one, right?
Oh, is it?
Yeah. Last name?
Stokes.
Mr. Stokes.
You got it.
I mean, we're gonna find out. 2011 France accident resulted from tires that had some type of defect or something like that, and it was made by Goodyear. So the two kids from North Carolina, so the parents tried to sue the parent company, Goodyear, in North Carolina for the subsidiaries of France, Luxembourg, and Turkey. And the original court said that since it was a subsidiary, that yes, they did have jurisdiction in North Carolina. But the appeals court said since they didn't have any management or advertising or stream of commerce or anything of that matter in North Carolina, then no, they did not.
Turns out it's a pretty simple case, isn't it?
Yeah.
You've got tires manufactured one place, an injury occurring in another place, and a company that's never done business in a third place, and they pick the place where the company's never been to bring a lawsuit. Is it fair for that court to hold jurisdiction over the Turkish tire manufacturer, even though the parent corporation is located here?
What about that thing you were showing us online about The Hague? Could we not go back to them and see if they had a reciprocal relationship?
That's getting them into court. Now we're on keeping them in court. What connection do they have with North Carolina? None. So they're going to be able to get out of it real quick and easy, right? Thank you, Mr. Stokes.
What's the quota for today, like two?
Vanderbilt. Walker.
We're trying to take all the cases.
We haven't gotten to Vanderbilt. This is Adam versus Sanger.
Let's switch it around.
I got him. Right off the reading assignment.
So you just said you was going in order. No, I can't keep up.
You're volunteering? Last name? Ms. Collins, go ahead.
Corporation brings the state of California against the Texas Export Import Company, California court rules for plaintiff who files a cross complaint in the court in California court. The Texas court dismissed the judgment against the defendant on appeal stated that the California did not have jurisdiction over the corporation cross complaint in which the judgment against it was rendered. The corporation was not in the state, therefore no jurisdiction over it for substantial service. Through the service of the cross complaint made by delivery of a copy of the cross complaint of the plaintiff's attorney was a voluntary action in demanding justice, which submitted him to the jurisdiction of the court. Therefore, nothing arbitration or unreasonable in treating him as though he were not there. All purpose for which the justice required is present.
That's pretty straightforward. You know what the short, abbreviated version of this brief is? Plaintiff, an out-of-state resident, files a complaint against somebody that's in-state. The defendant files a counterclaim and the plaintiff goes, oh crap, dismisses their claim, and they go ahead and take a judgment against the plaintiff on the counterclaim, and they're saying, whoa, you don't have jurisdiction over me. And the court clearly said the plaintiff having, by his voluntary act, in demanding justice from the defendant, submitted himself to the jurisdiction of court, there is nothing arbitrary or unreasonable as treating him there for all purposes.
So if you respond, you're in.
Now, if you voluntarily file a complaint in court, you are there for all purposes. You voluntarily submit to jurisdiction, you are stuck. So be careful what you ask for. Thank you, Ms. Collins. Yes,
Can I do Blackburn?
I haven't got to that yet.
It's next.
Okay, last name?
Is that
Last name.
Steigel, last name.
Go ahead, Ms. Stichel.
Okay, so Blackburn was a U.S. citizen, but he was a resident in France at the time, and he was subpoenaed to appear as a witness and with adequate service, and he failed to appear. And the holdings were that the U.S. had the power to require the return of a citizen resident whenever the public interest requires it. And the U.S. had jurisdiction in personam over absent citizens. And then in proceedings to punish for contempt, requirement of due process was satisfied because there was suitable notice and adequate opportunity to appear and be heard, and he just chose not to.
Okay. So the key thing that I got out of this case is that one of the duties of a citizen owes to his government is to support the administration of justice by attending its courts and giving testimony whenever he is properly summoned. What we're looking at is one of these concepts of international law, and that is when you are a citizen of a country, you owe allegiance to that country. Doesn't matter if you're outside that country or not. As it turns out, if you're a citizen of a state, you owe allegiance to that state, even if you're outside that state. It's one of the concepts of international law that we've adopted by calling the United States sovereign from other countries, and by calling each of our states sovereign amongst themselves. So it's a concept of sovereignty that you owe a duty of loyalty and obedience to the place that you are a resident citizen of. Yes, Mr. Stokes.
I had a question. I might have answered it myself in my head. I don't know what I'm asking. Right, so if you're in another state, you're still held responsible for basically the laws that's in your home state, right?
Yes.
But
the laws of your home state don't extend into other states.
Okay, so that's it.
So you have to obey the laws of the state where you are, but you owe a duty to your home state.
So what do you mean, like, owe duty? Because
Well, you got to pay taxes in your home state.
right.
And if you get a subpoena to appear in court in your home state, you better show up.
So my question is, like, the laws of certain things change from state to state. You know what I mean? So does that crossover, like if you get approved for, let's say, medical marijuana in California, does that crossover to another state?
You are still approved in California for medical marijuana. Can you have medical marijuana here in Alabama?
No, but if the state says it's medical marijuana law, that they do, like, you go to Colorado or somewhere else for recreation. But let's say it's medically there, but you had to go through certain steps. Can you say, no, I'm already medically approved somewhere else?
No, because each state has the right to pass its own laws on whether or not it's legal or not, and what requirements there are to become legal in that state. By the way, y'all know THC is legal in Alabama, right?
Weed.
Yeah.
It's gotta be.
No.
It's gotta be tougher.
It's a tablet that's prescribed by your doctor, and you usually only get it if you have a cancer diagnosis. It's called Marinol, and they prescribe it here in Alabama. Y'all don't know what that is? Google Marinol, and it is a legitimate cancer medication. Not if you don't have cancer.
That's the only way to get it.
All right, Petrowski versus Hawkeye Security. Let's see, who did that one? Ms. McNeil?
I did the last one.
Who did Blackmer?
I did Blackmer.
You got me down, Professor Baltimore?
Last name?
McNeil.
Yeah, I got you down.
Okay. I'm making sure.
All right, Petrowski. And that would be Mr. Baswell.
So this is a case where there's an automobile accident and the people involved in the accident have a policy with an insurance company that they're going back and forth with through different court processes. One's reversing and remanding, the other's saying that they are that they have jurisdiction to start that. The insurance company is claiming that they don't have personal jurisdiction for the suit, but they actually consented to waive their right to not be served. So it says the insurance company, by stipulation by which it voluntarily submitted to jurisdiction of the court without service of process, just as if personal service had been obtained, waived any right to assert the lack of personal jurisdiction over it. So they consented, basically.
They consented and waived, right?
Yeah.
So does he have any argument against personal jurisdiction if you both consent and waive to personal jurisdiction? Not a single argument, do you?
Can you repeat that? I'm sorry.
If you consent or waive personal jurisdiction, you have no argument to the court as to why they don't have personal jurisdiction over you.
Yeah, so if you consent or waive, you're just,
That's it. All right, now Vanderbilt.
Walker. Can I do this one? Rayshawn.
Mr. Walker, this one's yours.
Should I stand now?
As long,
was your weeknight class this crazy?
yes.
All right, I'm doing Vanderbilt versus Vanderbilt. Say 1957 case. First I'll do the facts. Well, first I do the issue. The issue is, may a court adjudicate a personal claim or obligation if the court does not have personal jurisdiction over the affected party. So facts. While living in California, Patricia Vanderbilt, who's the plaintiff, and Cornelius Vanderbilt, who's the defendant, separated after 4 years of marriage. Patricia moved to New York. Cornelius filed a petition against Patricia for divorce in Nevada. The Nevada court issued a final divorce decree. However, Patricia was never served with process in Nevada, did not know about the divorce petition, and did not personally appear in Nevada court. The following year, Patricia filed a petition for separation and alimony against Cornelius in New York City. Although the New York court did not have personal jurisdiction over Cornelius, the court sequestered property owned by Cornelius within New York in order to satisfy his financial obligations to Patricia. Cornelius appeared at a subsequent hearing on Patricia's petition and claimed that the full faith and credit clause compelled the New York court to enforce the Nevada divorce decree. The New York court agreed, concluding that the marriage had been dissolved, but nonetheless entered an order directing Cornelius to make designated alimony payments to Patricia. Cornelius appealed. The New York Court of Appeals affirmed the judgment. The United States Supreme Court granted cert to review. So the issue, again, is may the court adjudicate a personal claim or obligation if the court does not have personal jurisdiction over the affected party. So the holding, no. A court may not adjudicate a personal claim or obligation unless the court has personal jurisdiction over the affected party. Here, Patricia was not subject to Nevada court's jurisdiction at the time of the divorce decree, at the time that the divorce decree was entered, because she was not served with process and did not know about or personally appeared before the Nevada court. Consequently, the Nevada court lacked the power to extinguish any rights that Patricia had under the laws of New York to seek financial support from Cornelius. Therefore, to the extent that the Nevada divorce decree purported to affect Patricia's right to alimony is void. The full faith and credit clause does not obligate the New York court to give the Nevada divorce decree any recognition. The judgment of the Court of Appeals is affirmed.
So why didn't they give the full faith and credit to it?
To the status. And then the service was, there was no service because she wasn't a resident of.
State deprived her of her property rights.
She wasn't a resident. Where was he at? He's in Nevada. Yeah, she wasn't a resident of Nevada. She was in New York.
And Nevada can't deprive a non-resident of their rights.
Yeah, Nevada can't do anything. She was never living in New York. She had no. They had no jurisdiction over her because she had no ties to Nevada.
That's the answer, is they had no personal jurisdiction over her. So what we've been talking about this entire semester is, in order for you to have a valid judgment, you have to have subject matter jurisdiction, you've got to have personal jurisdiction, and due process. They didn't serve her, so that violated due process. They didn't even have personal jurisdiction over her because she wasn't a resident and had no contacts with the state. So they failed 2 out of 3 of those things, therefore the judgment's not valid. Real simple, right?
Yeah.
You can have a seat.
Thank you, sir.
You feel better?
Yes, I do.
May versus Anderson. I saw her your hand first. Last name? Okay, go ahead.
This is a case about a mother losing her possession of her children.
Now that sounds like their property, doesn't it?
Yeah.
Okay, go ahead.
So it's similar to the chapter case, I think.
She's saying you need to speak up.
Oh, who said that? I'm sorry. I just have a sweet little piece. Let's see. A mother's right to retain possession of her minor children, the custody of whom had been awarded to their father back divorce. The probate court entered an order allowing the writ and directed the children to be released to the father. The mother appealed. She lost again on the Court of Appeals, and she lost again at the Supreme Court level. She sought review at the United States Supreme Court, which treated the appeal as a petition. The Supreme Court finally came down and said, since the mother was not domiciled, resident, or present in the state where the decree was issued, jurisdiction was not obtained over her in personam. The court could not cut off her right to custody of her minor children. So they again went back to the full faith and credit clause of the Constitution. It says generally the domicile of children is that of the parent with whom they live, and only the state of the domicile may award their custody. Court of the state where mother was not domiciled, resident or present, could not cut off her right to custody of her children by awarding the children an ex parte divorce action.
Now that was in the 1950s. I'll tell you that Congress has since passed a law. It's called the Parental Kidnapping Prevention Act. And then the related uniform law that goes with that is the Uniform Child Custody Jurisdiction and Enforcement Act, which says when you're going to give full faith and credit to child custody determinations. And the Supreme Court got it right in this instance where there's no jurisdiction, and the court that actually is located where the children live should be the court that makes that decision. And literally, in Vanderbilt, you can't decide their property rights if you have no personal jurisdiction. And in May, you can't decide their liberty interests, which also includes custody of your children, without personal jurisdiction. So literally, the best place to have a divorce is going to be where you can get jurisdiction over everybody, because you can take care of their property rights and their custody or liberty interests all at the same time. But even if you don't, you can still have in rem jurisdiction over the marriage and at least get the parties divorced. But you can't do anything with their property rights or their children if you don't have personal jurisdiction over them.
Pastor Bodie, I don't understand in this case how it was determined that she was no longer domiciled in Wisconsin. Because it just says that she left to think things over and went to Ohio, and that to me did not sound as though she changed her domicile. So am I misunderstanding that? I didn't.
Well, how long did she stay in Ohio?
That's the 1950s term for separation.
Yeah. It was long enough that you could read between the lines and say, well, she ain't going back. That's circumstantial evidence.
What about intent? If she was just saying she was going there and think things over, was her intent to change her domicile?
When she got to Ohio and said, I'm not going back, or let a sufficiently long period of time lapse that it's obvious she's not going back, then that demonstrates her intent. But it's circumstantial evidence of intent.
So on that case that you're dealing with the child, how can that mother?
The one I'm no longer dealing
I'm
with
sorry,
because
yes,
it's
the
in
one-
Huntsville? Yeah.
Yes. How can that mother not have the child custody used against her when she took custody of that child and removed them from that jurisdiction? How can the court?
Because she gave custody to somebody else that lives up there.
And the courts can just say that's okay.
That was her permanent intent. And that wasn't the first baby she gave away to a family member either. Did I see another hand go up?
About
Yeah.
that case. So you're saying that if she didn't give the child to someone else, that the Madison County people that came and took her baby?
Oh, yeah, Madison County can still come take the baby because...
So let me get this right.
Yeah.
So you know what I'm saying?
People run away from DHR to go have babies, so the babies won't be taken away.
Like they got the power just like to go anywhere and just take your baby like that? Like,
Yeah.
You're still in the States.
They're looking out for the best interest of the child.
Man, get off.
No, they're looking out for the safety and welfare of the child.
Best interest, I'm just saying, it sounds like, you know, they can go to Africa or something, take the baby because she's a resident of Alabama or something like, or Michigan or 1,000 miles away to take the baby. Why wouldn't they just go to the jurisdiction she was in and do it through that? I mean, how can they?
That's what they should have done.
Yeah, like that's what I'm saying. How can their jurisdiction just be broadly swept throughout the whole United States where you're just going to take anybody's kid?
Well, no, the reason for that is you have attorneys who actually know what the law is, and you tell the court, no, you can't do that, and they say, yeah, you're right, and so they move it to where they have jurisdiction.
All right, I was just confused.
Yes, Ms. Savage. We hadn't gotten there yet. We still got questions on this one. Which one's next? Hess? Ms. Savage, go ahead.
The last week, well, originally has got into a crime in Massachusetts. The Hess was a Pennsylvania resident. Pulaski's suit has in Massachusetts State Court. Massachusetts had a statute that stated that individuals driving in the state they just had to provide consent to be under Massachusetts jurisdiction for claims arising out of accidents in the state and to substitute service of process in the state registrar. Under the statute, a copy of the summons.
Now, hold on, before you get too far into that. Y'all see what we're talking about? When you go into another state, you're assumed to already know what that state's laws are. And you consent by crossing the state line. All right, go ahead.
Under the statute, a copy of the summons and complaint also has to be sent to the defendant's residence by registered mail. Hess objected that Massachusetts had jurisdiction, but the court denied the objection and found in favor of Pulaski. Hess appealed on the ground of improper jurisdiction. The issue in this case is, may a state law declare that a non-resident motorist impliedly consents to state court jurisdiction and substituted service of process for claims arising from the non-resident's use of the state's highway. The holding is yes, and it's because a state law may declare that a non-resident motorist impliedly consents to a state court jurisdiction and substituted service of process for claims arising from a non-resident's use of the state's highways. The state has the power to regulate that use of its highway by non-resident. The state thus has the power to claim jurisdiction over a non-resident for claims arising from a non-resident's use of the state's highways. Cars are dangerous objects, and states must maintain the public interest of promoting the care of everyone who uses cars on their state highways. A state may do so by asserting jurisdiction over those individuals, residents and non-residents, that drive in the state. Accordingly, Massachusetts jurisdiction is proper in this case because the claim arose out of the non-resident's defendant's conduct while on the Massachusetts highway. The judgment of the lower court was affirmed.
Thank you, Ms. Savage.
You're welcome.
Y'all got questions about that? If you commit an act inside the state that results in an injury inside that state, then you have submitted yourself to the jurisdiction of that court. And that's the birth of a concept that we're going to call specific personal jurisdiction. Specific because the injury arises out of your conduct. It's the same transaction and occurrence. Your conduct gives rise to the cause of action. Next is Omni. Ms. Myers.
Okay, this is Omni Capital International versus Wolf, a 1987 case. The plaintiffs brought action against Omni under the Commodity Exchange Act in a Louisiana Federal District Court. The action is against both Omni Capital International and Omni Capital Corporation, both New York corporations, marketing and investment program. The plaintiff investors said that they were fraudulently induced to join the program by misrepresentation of its tax benefits and its profits. Omni brought into the suit as a third party Rudolph Wolf and Company and a British citizen, James Burleigh, who solicited business from Omni, acting as an agent for Wolf. Wolf and Gorley moved for dismissal. They said the court lacked personal jurisdiction. The district court agreed, noting they did not have enough contacts with Louisiana, the form state, to support jurisdiction. The Fifth Circuit affirmed that. Omni asked to use the Commodity Exchange Act, and the court unanimously held that it could not, because the act did not include a statutory provision for personal jurisdiction, and there were not sufficient contacts with Louisiana for use of its long arm statute against the two. So Omni asked the Supreme Court to fill the gap and use a federal long arm statute. The Supreme Court refused to acknowledge a federal long arm statute over the foreign defendants or the constitutionality of personal jurisdiction based on an aggregate of contacts with the U.S., and they urged a legislative solution to move forward.
That's it. In fact, they urged a solution through the Federal Rules of Civil Procedure as well, right? And who has the final word on the Federal Rules of Civil Procedure? Congress.
Well, final would be Supreme Court saying it's constitutional.
Well, to determine if it's constitutional.
Okay.
Yeah, that covers it. Philadelphia and Reading Railroad.
Dibs on you.
I want to do international harvester.
Got a hand raised.
We do have one. Last name?
Clayton.
Mr. Clayton. Go right ahead.
Philadelphia Reading is about Mr. McKibben. He was working for Philadelphia and Reading Railway, which is based in Philadelphia. He worked for him in New Jersey, which is another place that they operated. But he got injured while working for him in New Jersey, where he decided to file a suit in New York, where he lived. And basically what the case was saying is since the railway doesn't operate or has any type of business in New York, that was the wrong place to file a suit.
Wait a minute, don't they sell tickets in New York?
Yeah, they sell tickets in there, but that wasn't enough to say that they operated in New York.
Okay. So what this case introduces us to is these contacts that the business has with the state. Selling tickets was not enough for them to say that they were subject to the state's jurisdiction.
Correct.
Now, as it turns out, the first case they should have handled after Penoyer is International Shoe, where it tells you there has to be sufficient minimum contacts. In this case, you have minimum contacts which are not sufficient. And so there's going to be a dividing line at that point. Thank you, Mr. Clayton. A dividing line on how many contacts does it take to become sufficient. Selling tickets is just not enough. Now, International Harvester versus Kentucky. Ms. Dudley.
Okay. So, in this case, Glenn Denning, which was a defendant, owned an International Harvester dealership and worked as an International Harvester salesman before becoming a farmer and frequent trader of farm equipment. Glendenning bought 3 tractors from Jack L. Barnes, who was another international harvester dealer. Glendenning paid him $16,000 in cash for all 3, which were really worth about $22,000. Barnes indicated in the order form and the bill of sale that in addition to the cash, Glendenning had traded in 4 other tractors valued at $8,700. Glendenning admitted that he traded in no tractors, that he knew a great deal about how International Harvester's pricing method was, and about their dealers and retaining a security interest, and that falsifying the transaction documents was likely to mislead International Harvester and other creditors. Nevertheless, when an International Harvester rep called Glendenning about the deal, he lied and told him that he had traded in the tractors. International Harvester, the company itself and their credit company, sued Glendenning for wrongful conversion of the 3 tractors. He argued that damages were improper because he was a buyer in the ordinary course of business. The jury agreed, and International appealed to the Texas Supreme Court. And the holding was based on basically a buyer in good faith is one who purchases goods with good faith, meaning with honesty in fact and with knowledge that the transaction violates the ownership or security interest of another. Glendenning signed documents that he knew to be fraudulent and lied to the International's reps when they called. His conduct was fraudulent and in bad faith. The judgment of the trial court is reversed, and judgment is that International Harvester Company and International Harvester Credit Corporation should receive the sum of $24,049.99 together with interest at the rate of 6% from the date of the judgment until paid.
So was the company subject to Kentucky's personal jurisdiction?
Yeah, that's how they got the.
So that was enough business. Selling tickets wasn't enough, but selling equipment, at least at that level, was enough. So we're setting ourselves up to look at international shoe with these cases. What does constitute sufficient contacts? And then, did they really have specific personal jurisdiction if it arose from those contracts? Yeah, but they didn't argue that, did they? They argued minimum contacts, and the court still came down and decided that that was enough. Even though selling tickets for passengers wasn't, this one was. They said it was a close call, but they fell on that side. All right, now international shoe, Ms. Willis.
There was a point in time where government was trying to set up an unemployment fund or something like that people had paid into. International shoe did not want to pay into this fund or didn't pay into it. They were saying that they didn't have a registered agent or an office in this area, but they came to like other places like Hotel and I just said a couple of spaces like hotels. So it was trying to get around the registered agent thing, but this case ended up saying that there was minimum contracts, this established minimum contract rules because they had continuous and systematic activity and they had specific jurisdiction because they purposely availed themselves to the area. So it established that if you come to this area for the benefit of making money or benefits and implications of the area, there's some lawsuits.
Okay.
But it's like a keystone.
I'm gonna have to disagree with you about specific personal jurisdiction, and here's why.
Okay.
What was this lawsuit about? Was it about the sale of shoes? Isn't that what International did inside the state of Washington, was the sale of shoes?
It was about the money that they were making
Oh, no. Now, what happened after they saturated the market and sold all the shoes they could? What'd they do? They moved out. And what'd they do with all the people they had hired? They laid them off. And so what did those people do? They went and filed for unemployment. And yet, International Shoe had not paid any money into the unemployment. So was it specifically toward the sale of shoes that they brought them into court? No, it was related to the non-payment of unemployment. So it wasn't specific personal jurisdiction. They had to go on general jurisdiction. And what the Supreme Court said in that case is, in order to go general jurisdiction, you have to have sufficient minimum contacts. Hold on, we're getting to that. You have to have sufficient minimum contacts such that it does not offend the traditional notions of fair play and substantial justice to require a non-resident defendant to come into the forum state to defend against an action. You have to have sufficient minimum contacts such that it does not offend the traditional notions of fair play and substantial justice to require a non-resident defendant to come into the forum state to defend against an action there. All right, so with our Kentucky case and our New Jersey case, the New York case, selling tickets, were those sufficient minimum contacts? Sales of tickets weren't, but the sale of tractors was. So you have what is sufficient contacts, sufficient minimum contacts. The next part is such that it does not offend traditional notions of fair play and substantial justice. So what are our traditional notions? What are our traditions? All right, how did a judge back in Old England get somebody brought before the court? And they summoned them and they'd send the sheriff out. And where did the sheriff usually go? Only inside their county. So the tradition is if you catch them inside your jurisdiction, that's tradition, that they can be held to answer to that complaint. So that's traditional notions of fair play. Fair play is you don't induce them to come there via fraud. Did I tell this class about the Alabama-Auburn tickets?
Yeah.
You can't say you've won 2 tickets and then not give them the tickets. That would be fraudulent, so that violates fair play. For civil, you can't do that. For criminal, they got an outstanding warrant, you can do that. Fair play and substantial justice to require a non-resident defendant. Because remember, if you're a resident, you owe allegiance to your state. So we're only looking at non-residents to come back into a forum state to defend against an action. Now that's general jurisdiction. If their act, like Hess versus Pulowski, if their act inside the state, a car wreck, causes the actual injuries, you've got specific personal jurisdiction. But in this case, it wasn't because of the sale of shoes, which is what they did. It was the non-payment of unemployment. So it wasn't their conduct in the state. That's why they have to resort back to general jurisdiction. Because had it been it was related to the sale of shoes, like defective shoes, they could have had specific personal jurisdiction over them. But because it wasn't related to their activities, they had to rely on general jurisdiction, which is not as good as personal jurisdiction. Yes? Hi, Ms. Etherington, you're here. I'll get you on the roll. If you come in late and you wave at me, I'm assuming you want to be on the roll.
You know what we want. You know what we want today. We want our check mark.
Oh, yeah, did you get,
Yeah, I got you on there when you volunteered. Helicopteros. Can you pronounce the name of the case?
I'm gonna say the short name. Helicos. Helico.
I can't hear you. We've already got two more here that spoke up before you did. Ms. Heathington, go ahead. You had so much exuberance. Go ahead.
Let's try this. Helicopteros, nationalities, dance Colombia. Versus Paul. This is a case in which the helicopteros, the defendant, a Colombian corporation, was engaged in business providing transportation and oil. Transportation for oil construction companies in South America. They contract with a Peruvian company, which was founded in Texas to assist the construction of pipelines. Negotiations for this deal occurred in Texas. The contract stated that all lawsuits arising out of the transaction will be tried in Peruvian courts. And here it gets interesting. Purchased approximately 80% of the helicopter fleet from another Texas company named Bell Corporation. They paid $4 million to the Texas company for the helicopters and their accessories. And potential pilots were periodically sent to Fort Worth, Texas to receive flight training from Bell helicopters. The management team was sent to Texas for training.
Before you go much further, you know what kind of training they get in Texas with the helicopters? Just a matter of trivia. They take them up in the helicopter up to so many thousand feet, and then they turn the engine off. No, it's not a stall out. It's to see if you can get the engine restarted on auto gyrate.
Yeah, they do the same thing as jet, called EPU.
Yeah. So I mean, that's part of their job in Texas is to take you up in a helicopter and turn the engine off. Okay, go ahead. Just so you know what they're trying to do, these people from Colombia.
Okay, on January 26, 1976, a helicopter owned by Helico crashed in Peru, killing 4 United States citizens. Hall and other representatives of the 4 descendants filed a wrongful death suit in district court in Texas. And Helico made a personal appearance argued that the court lacked personal jurisdiction. The Supreme Court ruled that Texas had personal jurisdiction. And Helico went for a reckless tort to the United States Supreme Court for case regime. And basically what happened is that they did not have personal jurisdiction.
Okay. Say this. Cert. Eor. RE. Cert Eor RE.
Do that one more time. It's not like
That's it. They held that there was no personal jurisdiction. Now, why your authors put this case in here where they did instead of after Asahi Metal, I have no clue. Asahi Metal, you know, is the stream of commerce case where you put products into the stream of commerce. This case, the argument was they're taking products out of the stream of commerce by going to Texas and buying these helicopters. Therefore, they have stream of commerce jurisdiction over the Texas company because they bought the materials from the Texas company out of Texas. And that's not what stream of commerce is. It's when you put products into the stream of commerce that they test, not when you take them out. So they did not have personal jurisdiction. Thank you, Ms. Hetherington.
Who should the decedent have filed suit against in this case? I mean, they had 4 people that died in this helicopter crash. Who should they have gone after?
The Peruvian company, I guess. You had to sue in Peru. That's what they agreed to.
What if they had like an alter ego? That's what they were.
They set it up that way.
They had a consortium or whatever was the alter ego.
Well,
But why did they?
but you have to show that they actually
That's right.
exercise control.
Yeah.
And they may not have had the evidence to do that.
It was a.
Are you volunteering for the next one?
Yes, sir.
Huh?
Yes, sir.
Okay. Any other questions about helicopteros? All right, Bird versus Parsons. Last name?
Gunter.
Mr. Gunter, go ahead.
Plaintiff sued based on a trademark infringement. The other internet company was using this trademark. The lower court dismissed due to lack of jurisdiction. However, the defendant's internet business in Ohio had 4,600 subscribers to it, and the Supreme Court, the Sixth Circuit Appellate Court deemed that it availed because it had that many subscribers in Ohio. It had the minimum contact standards of doing business in Ohio. It also availed itself, by doing business in Ohio, it availed itself to the laws and protections and privileges of Ohio.
Okay. Some of the key things to get out of this case start at head note number 1. A party seeking to assert personal jurisdiction bears the burden of demonstrating that such jurisdiction exists. You want to rephrase that? If you raise it, you what? No, if you raise it, you prove it. If you fail to raise it, it's what? Right, but if you raise it, you have to prove it. So if you are suing somebody, you're the plaintiff and you're suing somebody, you are raising the issue of personal jurisdiction. You're going to have to prove it.
But he was pro se.
So he didn't know that he had to prove it. But that's still his duty. Again, this points out to you the fact that personal jurisdiction is one of those things you need to consider before you ever file suit. That if you're going to name a party in a lawsuit as being a defendant, you're going to have to prove that there's personal jurisdiction over them in order to keep them in court. Can you get them into court even if you don't? Yes, all you got to do is issue them a summons and get them properly served. That's how to get them into court. But how to keep them in court is you've got to prove your personal jurisdiction. And if you can't do both, then you probably don't need to name that person as a defendant, or you need to find a different court that might be where they're subject to personal jurisdiction. Notice also that not only are they pro se, but they did not have any jurisdictional averments, and that goes against our requirements for civil procedure. You have to have a jurisdictional averment. At head note number 7, it says personal jurisdiction can be either general or specific, depending on the nature of the contacts that the defendant has with the forum state. So, what types of contacts do you have to have specific personal jurisdiction?
Substantial?
Substantial and continuous?
Hold on. What do you have personal? No. Specific personal jurisdiction, the injury has to arise from your conduct. And it doesn't matter if it's a single event like Hess versus Pulowski. It has to arise from your conduct, and you have specific. If it does not arise from your conduct, then otherwise you need to have sufficient minimum contacts like systematic and continuous. Yeah, remember that specific personal jurisdiction is better than general because their conduct actually gave rise to the cause of action. If their conduct did not give rise to the cause of action, then it's unrelated, and the only way you can drag them into court is if they otherwise have enough contacts with the state. Yes, ma'am.
So specific jurisdiction arises from the activity. The injury arises from the conduct.
The injury arises from their conduct.
And
specific minimum contact?
No. Arises from their conduct.
Period.
Period.
In general, goes into minimum contact.
Yes.
Thank you.
And if you have to get down to where you have general jurisdiction, you're pretty desperate on trying to make an argument on jurisdiction. Because you're not saying that what they did caused you injury, giving you specific personal jurisdiction. You're just saying, oh, well, they didn't do anything here, didn't cause me any injury here, but I still want to sue them here. Well, what basis do you have to sue them there? You got to show that they have at least enough minimum contacts that it does not offend traditional notions of fair play and substantial justice to require a non-resident defendant to come to the forum state to defend against an action they're pending. Everybody got that in your notes already? I've only said it like 6 times. If you don't have the clue yet, that key phrase is one you need to know and to be able to cite for bar examiners, is that in order to get personal jurisdiction over a non-resident defendant, they have to have sufficient minimum contacts such that it does not offend the traditional notions of fair play and substantial justice to require a non-resident defendant to come to the forum state to defend against an action. That is general. Because if you've got them that it arises out of their conduct, you don't have to rely on general jurisdiction. You've got them on specific. In fact, specific personal jurisdiction. In fact, let's go ahead and start making a priority list.
Yeah, let's do that. I have a question. When you file, you basically say, A, I'm doing it this way, but if A doesn't work, I'll do it this way. You give them 2 choices, or you only can swing at it one time in your filing.
I didn't hear you. Go ahead.
When you're doing your filing and you're asking for specific, in your filing, is there verbiage that, if Your Honor, you don't see specific, then here we have general? Or do you just basically ask for specific? You go in there with a B plan, I guess is the...
Actually, if you just name them as a party, then you have raised personal jurisdiction as an issue.
Okay.
You get them served and you have the requirement that they answer the complaint. But then if they say you don't have personal jurisdiction over me, then you're going to have to go into exactly how do you have personal jurisdiction over this defendant. And right now we're building up a chart of what's your worst argument all the way up to what's your best argument as to personal jurisdiction. Right now, we have covered so far, number 1, that they consent, waive, or voluntarily submit to the jurisdiction of the court. If you've got that they consented to, they waived jurisdiction, or they voluntarily submitted themselves to the jurisdiction of the court, there is no argument that they can raise that says, you don't have jurisdiction over me. Why is that? Because they've already consented to it, they've already waived it, or they've already voluntarily filed something in court asking for relief. Voluntarily submitted is Adam B. Sanger. The waiver and the consent is that next case that says they agreed to waive personal jurisdiction. So they consented by agreeing to it, and they also wrote in there that they waive it. That is the absolute best type of personal jurisdiction, is one that they can absolutely raise no argument against. Y'all would agree to that? And if they have an argument against personal jurisdiction that they fail to raise in their answer, what have they done? They've waived, which is absolute number 1 best type of personal jurisdiction. That, yes, Judge, if they had an objection, they should have raised it in their answer. Now it's waived. And what happens if you've got a defendant who commits an act outside the state, where the injury occurs outside the state, it has no connection with the state, but you go ahead and sue them anyway, and then they file an answer which doesn't raise an objection to personal jurisdiction. They consented to it, which takes them out of category number 6 and puts them into category number 1. You've got the best type of personal jurisdiction you can get. So the idea is you want to get it into a higher level of personal jurisdiction. Now, what's better than general jurisdiction? Specific personal jurisdiction is better than general. And why is it?
Because it has an ad.
Because they have an inside state.
Because it relates to their conduct, right? Well, we'll get to that in a minute. If it arises out of their conduct, then it's better than if it doesn't arise out of their conduct, right?
Yes.
I mean, literally, why would the state of Alabama want to exercise jurisdiction over somebody that does something in Georgia that causes an injury in Georgia?
Our dockets are full.
Yeah, and the courts don't want to exercise jurisdiction, right? There's a presumption against the federal courts exercising jurisdiction unless you can absolutely prove to them that they have jurisdiction. Number one, subject matter jurisdiction. But then number two, if you can't actually show that you have personal jurisdiction, what's the first thing federal courts want to do? Get rid of your case. They want to get rid of it if you can't serve them within 90 days. They want to get rid of it if you can't show subject matter jurisdiction. And now they want to get rid of it if you can't show them personal jurisdiction. And I think our last case, which is Rogas AG versus Marathon Oil. I'll brief that one real quick and easy. Ordinarily, a court looks to subject matter jurisdiction first to see if they can even decide a case. But that Marathon Oil case says we don't have to look at subject matter jurisdiction first because we know if we don't have personal jurisdiction, we can throw it out on that ground too without even looking at subject matter jurisdiction. So they don't have to look at one first versus the other. They can look at either one. And if they don't have jurisdiction to enter a judgment, they can throw the case out regardless of whether or not it's subject matter jurisdiction or personal jurisdiction. That's pretty simple, right? And then what's the other ground they can throw a case out for? Violating due process. So, what's our next one? All right, general jurisdiction. And this is still out of Byrd versus Parsons. It's head note number 8. General jurisdiction is proper only where the defendant's contacts with the forum state are of such continuous and systematic nature that the state may exercise personal jurisdiction over the defendant, even if the action is unrelated to the defendant's contacts with the state. Unrelated, so the act is outside the state and the injury is outside the state, has nothing to do with the state. They can still do it if their contacts are systematic and continuous. Next is Doe versus Unical. Ms. Felton, have you already done one? Okay, go ahead.
Okay. This is a human rights violations lawsuit against Unical. In September of 1996, 4 Birmingham villagers filed suit against Unical under the Alien Tort Claims Act. And in October of 96, another 14 villagers also brought suit alleging various human rights violations, including forced labor, wrongful death, false imprisonment, assault, IIPD, and negligence, all related to the construction of a gas pipeline. The plaintiffs also filed complaints to the Superior Court of California. The court ruled against Unical. District Court dismissed the case on grounds that Unical could not be held liable unless they want military to commit abuses and that plaintiffs had not shown it.
Plaintiff's appeal and a three-judge panel of the U.S. Appeals Court reversed portions of the district court decision, allowing the lawsuit to go forward. Later, the circuit court vacated the panel's decision and agreed to rehear the panel before an 11-judge in-bank panel. Both the plaintiffs filed their lawsuits in Montana State Court, although neither of the plaintiffs resided in Montana and the events underlying their case did not take place in Montana. BNSF moved to dismiss both lawsuits for lack of personal jurisdiction. The issue reached the Supreme Court of Montana, which sustained jurisdiction on two grounds. First, the court concluded that the personal jurisdiction of the railroad was authorized, which provided an action that may be brought in the district court of the United States in the district of the residence of the defendant, or in which the cause of action arose, or in which the defendant shall be doing business at the time of commencing such action. Second, the court concluded that Montana could also exercise personal jurisdiction because BNSF had sustained operations in Montana to the extent that it could be deemed at home in Montana for jurisdictional purposes.
Okay, now you want to do Doe versus Unical? That was BNSF. That's the next one. Doe versus Unical.
No, it doesn't matter what time she is.
I can't.
Okay, she
I can do it. You have a volunteer over here.
I hear. You missed one.
I think she did it both. Like I heard.
Huh?
She started with Unical.
I tried to skip, I tried to shorten it, then I kind of went to the next day. Where I should have stopped.
One of the key things to look at in Doe versus Unical is they talk about specific personal jurisdiction starting at 3A. After California's long arm statute, they go into A, specific jurisdiction, whether there's purposeful availment or the relation between claims and contacts. And then they talk in B1 of attributing contacts of subsidiary to the parent corporation and also the alter ego. So if you're going to submit a parent corporation to personal jurisdiction, you've got to prove that they had more hands-on involvement with the subsidiary than just simply managing the subsidiary. They have to essentially be the operating agents or the alter ego of it in order to hold them, and that would have been helpful in the Goodyear tire with the Turkey and the France, Turkey and Paris. But as it turns out, they weren't able to hold it in that case. All right, BNSF, you covered that one too.
What's the takeaway on that one?
Montana Supreme Court relied on state law, which personal jurisdiction could be asserted over persons found within Montana. And whether or not the company is at home in the state, essentially their presence has to be there such that they can be considered to be at home in the state. Not just, they're selling tickets there, but is it enough that you can consider it to be technically a residence or at home in the state? All right, so our next one, McGee. I saw his on first. It's been up for like 5 minutes. Last name?
Cruz.
Mr. Cruz, go ahead.
McGee was the beneficiary over Franklin's life insurance policy. Franklin committed suicide, and she resided in California. She had this policy, and she had been paying for it while she lived in California. McGee tried to collect on it in California. The court in California awarded judgment, but he was unable to collect because so he filed in the state of Texas where it was rebuffed for due to improper service. The Supreme Court said that a state court does have jurisdiction over an out-of-state company if the company has substantial connections, contacts with the state.
Okay. And did they have substantial connections?
Yeah, because they were doing business with her. That's what I took away from it.
Well, it was specifically related to the life insurance, right? They were sending her bills for the premiums, and she was paying the bills for the premiums. So would that be specific personal jurisdiction, or would that be general jurisdiction?
Specific.
Because it's related out of the contract for life insurance. Thank you, Mr. Cruz. Hansen versus Denkla. Ms. Johnson, go ahead.
Donner, who was a Pennsylvania resident in 1935, had set up kind of a trust. And then she moved down to Florida and she died. And then her will was probated down in Florida where she had 3 daughters, so to speak. She had 2 that were named and then a third one that was supposed to split. Well, 2 of them were supposed to split the majority and then there was a third one. Hansen was the defendant who was the executor of basically the will. And so Denkla, who really had $500,000 per person, not just $500,000 overall, but $500,000 per person to exercise between each, really. And then Hansen wouldn't have a share of the estate. That was her argument. The Florida court assumed jurisdiction over the Delaware trust and then said that basically when she was in Delaware that she was paying on it there, but then she moved down to Florida, which basically it's an issue of does the Florida court have jurisdiction to issue an injunction against the Delaware estate or the trustee? And the answer is yes, they have personal jurisdiction over the defendants who have minimal contacts to the state. I agree, she can assert this because, I mean, she was paying on it in Delaware, but then she moved down to Florida, right? But then she had an executor of the estate. She conducted her business in Florida. She died in Florida. She had someone execute the will in Florida. The takeaway from here is that you must have a minimum contacts rule essentially to be able to have personal jurisdiction in that state and execute the will. That's what I take away from it.
That's it. You have to have minimum contacts in the state. And did the trustees have minimum contacts in Florida?
No, they didn't, but
No. In fact, there's another exception that you need to know about. For federal courts, they don't usually get involved in probate matters. And in probate matters, you usually have to set up not only the administration where they die, but then you have to do something called an ancillary administration wherever else they have property. And the reason for that is the ancillary administration is done in the state where the property is located, so the court has jurisdiction over the people in that state to do something with the property. And because that didn't happen, the Florida court decided everything without doing an ancillary administration up in Delaware. They didn't have jurisdiction over the Delaware agents, but had they done an ancillary administration in Delaware, then the Delaware courts would have had jurisdiction over the Delaware agents. And it would have been a completely different outcome. So yes, they still have to be doing sufficient minimum contacts, even over somebody that's just managing property for another person. Now, could they have gone in rem against the Delaware property? Not in Florida. Could they have gone in rem in Delaware?
yes.
They could have done in rem in Delaware, but they did not do that. And I would venture to say that somewhere along the way, somebody in court said, you know, it'd be a whole lot easier if you did administration in Delaware. And they said, no, I want to spend thousands of dollars to see if I can fight it here.
It's interesting nowadays with everybody retiring in Florida, how many times you kind of run into that now.
Okay, so why do you move to Florida anyway?
No state income tax.
No tax. Same reason OJ went down.
You moved there to die. You don't want to die anywhere else, do you? You want to die where the weather's warm and you don't have taxes. All right, here's another interesting statistic for you. If half of all marriages end in divorce, how did the other half end?
Happy?
Death. She's right. They end in death. Isn't that what the vow is? Now, where are we? Hanson. Worldwide Volkswagen.
I'll do that.
I saw this arm over here first. Last name? Ms. Leith, go ahead.
Harry and Kay Robinson purchased a car from Worldwide Volkswagen Corporation in New York while they were still residents.
They bought a Volkswagen?
Purchased a car. Volkswagen. Okay. The next year, the family left New York and moved to Arizona. On the way, they were struck by a car in Oklahoma. Miss Robinson and her children were severely burned in that car accident. In a crash. The Robinsons filed a process liability suit against Worldwide, claiming that the fire was a result of the defective design of the car. Worldwide made a special appearance to the district court, claiming that Oklahoma's exercising jurisdiction over their violated the company's due process rights. Worldwide, a New York corporation, conducted no business in the state of Oklahoma. The district court ruled against Worldwide. Worldwide then sought a writ of prohibition in the Supreme Court of Oklahoma to stop the district court's Judge Woodson from exercising personal jurisdiction over them. The Supreme Court of Oklahoma denied the writ. Worldwide then petitioned the United States Supreme Court, and the case was granted cert. I can't say it. If the issue is foreseeability alone sufficient to authorize the state court's assertion of personal jurisdiction over a non-resident defendant that has no contract, ties, or relations to the forum state? No. The due process clause of the 14th Amendment limits the power of the state court to assert personal jurisdiction over a non-resident individual.
Okay, and in this case, they mentioned this thing called foreseeability, didn't they? Was it foreseeable for Worldwide to be dragged into court in Oklahoma?
Absolutely.
You're driving all right.
Should have been.
Yeah.
All right, let's do a hypothetical. What if, was it the Robinsons, decided that they wanted to take a trip across country and they went into the dealership and said, we're looking for a good car to drive out west?
Okay.
What if they'd said that? Would somebody at Worldwide might anticipate that they would be caught somewhere out west?
Yeah, but where's out west? I mean, you could go from New York, you could go across the northern part of the country, and now
All
you're
right.
in Oklahoma.
So what if they said we're going to drive Route 66
That's
through Oklahoma?
Well, even knowing that it would be used, that doesn't suffice the limited context that we're
And then here's one even better. What if they decided, hey, we're reading this book called The Grapes of Wrath, and we want to recreate their trip?
Would you have a specific warranty because you told the salespeople that's your intention for that particular?
Not a warranty, but would it be foreseeable that they would be in Oklahoma if they'd have given that information? See, I would like to have a different hypothetical on this. Instead of buying an Audi, say it was a VW bus with one of them little camper hoods on it, and they're driving out west. Wouldn't that have been a whole better case?
I mean, you would be foreseeable, but that's not going to
But
be
still,
enough.
their unilateral action.
Yeah, even if it's foreseeable, that's still not enough. As Ms. Dudley points out, you still have to have minimum contacts. The Supreme Court only introduced this foreseeability in here to confuse the issues.
So you're arguing that the state is foreseeable, not driving on a road itself is foreseeable?
Right. Not foreseeable to the forum state. So is it foreseeable to Oklahoma? No. Is it foreseeable they'll drive on a road in New York?
Yeah.
Absolutely. They bought the car in New York. They could assume they're going to drive it in New York. What about New Jersey? Yeah, New Jersey's close enough to New York, isn't it?
Connecticut.
What about Philly? Close to Philly. What about Atlanta? You kind of a whole lot further removed away from the area where you bought it. But besides that, they still didn't have sufficient minimum contacts with Oklahoma, did they? All right, Culco. Who did worldwide? Ms. Lee. Gotcha. Culco versus Superior. Last name.
Johnson.
Ms. Johnson, go ahead.
So this is a case where two people were married in California but moved to New York after his military service, where they actually lived. When they separated, she went back to California, he stayed in New York, and at some point she went back to New York to sign a separation agreement. After that was done, she went to Haiti and got a divorce, and she went back to California. The kids were going to live in New York with him during the school year, and then in California with her during the summers and vacations. But at some point, a few years later, the daughter went to live in California, and then the son also went to live in California. So then she asked the California courts to recognize the Haiti divorce decree, and sought full custody of the children, and then wanted an increase in alimony and child
So
support.
what connection did the marriage have with Haiti?
None.
Okay, go ahead.
And so he challenged the California court's jurisdiction over him.
By the way, people used to do that with Mexican divorces too. Go ahead.
Okay. So he challenged their jurisdiction over him, and they said, yeah, you don't have enough contacts here for us to have jurisdiction over you. So,
Any questions about that? Y'all, we've still got this many cases to go, and that's more than half. So you're going to have to be on a 2-minute drill to get through these briefs.
I could do the Hustler magazine.
Why am I not surprised? Go ahead. Go ahead.
Okay. So the plaintiff is a resident of New York, and she's bringing action against Larry for 5 counts of libel, but the statute of limitations had ran. Hustler is headquartered in California, but it was incorporated in Ohio. She was going to bring suit in Ohio, but it was dismissed because the statute of limitations had expired. The only state that the statute of limitations had not expired was New Hampshire. So they questioned the jurisdiction of New Hampshire, and the court ruled because of circulation and the number of the 10 to 15,000 people that were subscribers or that the magazine reached in New Hampshire, that their long-run statute would grant them jurisdiction. So, because the state had an interest in addressing the injuries for the sale of the magazine within the state.
Okay, so what did they say about minimum contacts with relation to a plaintiff?
Doesn't that it doesn't. New Hampshire jurisdiction over the defendant based on the contacts would satisfy the requirement of the due process clause, the minimum contacts between the defendant and the state, because the state has the number of what I think it was 10 to 15,000 people this magazine reached. That gave them enough of an interest to protect the people within their state.
Okay, but what about the long arm or the minimum contacts analysis with respect to the plaintiff.
Not required.
Doesn't apply, does it?
No.
The plaintiff doesn't have to have minimum contacts. Why not? Because the plaintiff is voluntarily submitting to the court by filing their complaint there. There's no question as to whether or not there's personal jurisdiction over a plaintiff who files a complaint in that court. So minimum contacts does not apply to plaintiffs.
Does it go back to first to raise, the first to have to prove? You raise it, you gotta prove it?
Well, if you file a complaint in a court, do you have to prove that the court has personal jurisdiction over you? That's it. You voluntarily submitted. So minimum contacts does not apply to plaintiffs because you pick the court and you submit yourself to the court.
Well, it was favorable because of the single publication rule in New Hampshire.
Well, it was favorable because they had the names of 10 to 15,000 people that subscribed to it.
Yeah, but it didn't limit to recovery and distance.
Y'all, that was supposed to be funny. They had the names of all those people. They weren't just the ones that bought them at the gas stations either. They
got them out of the mailbox.
got them out of the mailbox. And is that sufficient? Is that, no pun intended.
Yeah. No.
Is that minimum contacts, 10 to 15,000 that you're actually mailing to individuals? Now, would it have been different if they just had a truck taking 10 to 15,000 copies through the state and the truck was involved in a wreck?
That would be.
Well, it's still, yeah, but it says it.
Well, it depends on if the truck's responsible for the wreck, would jurisdiction apply?
Yeah, it has nothing to do with the libel, does it? See, specifics got to be related to the conduct. So, yeah, 10 to 15,000 is probably enough to show minimum contacts, at least to be sufficient for it.
I wonder how many times Larry Flint's been sued. Yeah, I mean.
Which state?
Yeah.
That's a good question. All right, Calder versus Jones. Yes, ma'am. Last name?
Watley Hill.
Ms. Watley Hill, go ahead.
Okay, so this is.
Well, before you start,
Yeah.
who is Shirley Jones?
I have no idea.
She's the mother in the Partridge Family.
Oh, that's definitely what I would. Partridge family.
Oh, you're a radio cover, weren't you?
I love this. Wait, the Partridge family was the murder?
Yeah, that's the ones.
Okay.
Now you know who she is, so go ahead.
Okay, so Shirley Jones lived and worked in California, and she is the plaintiff, and she is bringing suit against National Enquirer, its editor, Calder, and the writer of the story, South. So, National Enquirer is based in Florida, and Jones, like I said, is based in California. So Calder itself in Florida objected to California having jurisdiction. And so they were granted certiorari. The Supreme Court, the issue is whether jurisdiction of a libel suit is brought in the state that the victim is appropriate. And the rule is personal jurisdiction is proper over a defendant where the defendant has certain minimum contacts, such as the maintenance of the suit does not offend traditional notions of fair play and substantial justice. So the court found that that it was appropriate, the personal jurisdiction is proper over the defendant where the defendant has certain minimum contacts such that maintenance of the suit does not offend traditional notions of fair play and substantial justice. So in this case, the contact was the fact that Jones lived and worked in California, and the effects of the article were personal to her where she resided.
Repeat that again. Just that last sentence.
The effects of their articles were
affected her where she lived.
Right.
What this case is known as is called Calder effects. C-A-L-D-E-R effects. E-F-F-E-C-T-S. And what that is that you've committed an act somewhere, and that somewhere in this case would be Florida, where the effects of your conduct are felt in California, which is outside the state in which you committed the acts. But it happens to be inside the state where Jones felt the injury. So now we've got specific personal jurisdiction broken down into two things. Number 4 on our chart is going to be specific personal jurisdiction where both the act and the injury occur in the forum state. And that's the Hess versus Pulowski. You're in a car wreck, you've done something in the state, the injury occurs inside the state. That is a little bit higher up than if the act was committed outside the state, but the injury was still felt inside the state. And that's number 5, Calder v. Jones. And those two, number 4 and 5, whether the act is inside or outside the state, but the injury still occurs inside the state, both of those are better than the act being committed outside the state and the injury is outside the state. And in that case, you don't have specific personal jurisdiction because the injury is not related to the act, right? And the act's not inside the forum state or the injury is inside the forum state. So in that case, you have to look at specific minimum contacts to see whether or not you can get jurisdiction over that non-resident defendant inside the state where neither the act or the injury occurred. So we're going to put minimum contacts. Y'all see why number 4 is a little bit better than number 5? Because you've removed one more thing from the forum state. You've removed the act. The act in number 4, the injury on the highways that resulted in injuries in that state, both of those are in the state. Calder effects, the act was done outside the state, which was in Florida, but the injuries still occurred inside the state. So they've extended specific personal jurisdiction to even acts outside of the state as long as the injury was directed to a person inside the forum state, and that's called the Calder effects. And that was Ms. Whiteley Hill. Thank you, Ms. Whiteley Hill.
Does it have to be foreseeable that the effect will happen there? Or?
Not really.
As long as it happens there.
It happened there, right? All right, Walden versus Fiore. Mr. Davidson?
Two citizens in Nevada who've been Caribbean gambling. They're going through Atlanta, going through the Atlanta airport. The police seized, they had a large amount of cash. The police seized that cash, thinking that they're drug dealers. Turns out they were not drug dealers. They were just good at gambling. Planned to go home to Nevada and sue the officer in Nevada, and claimed the officer was caused an effect in Nevada because that's where they live. They no longer have possession of their money there. The Supreme Court held there was no jurisdiction because it was just happenstance that the plaintiffs lived in Nevada. That unlike the last case where they kind of reached out to California, the police officer never reached out to the state. He just reached out to the plaintiffs, basically. He wasn't trying to harm anybody in the state. It was just those plaintiffs.
That's it. There was no connection with the state, and therefore no minimum contacts, right? Ms. Gale. Burger King, go ahead.
Okay, this is a case, 1985, where there was a defendant who breached a contract with Burger King.
A franchise agreement, right?
Franchise agreement. They want to accept the franchise in Michigan. And Burger King their headquarters is in Florida.
Miami.
So they breached the contract, the franchising contract, and they were sued by Burger King in the state of Florida. The defendants asserted that they did not, that the state of Florida did not have personal jurisdiction on them. And it was actually initially the trial court, or the initial court said that they did, and then the motion was denied at the trial court, and the judgment was reversed on appeal. So this, continued to go
Philip, and due to the long-arm statute there, Florida did exercise jurisdiction, and it would be fundamentally unfair to infringe on due process. The issue here is the contact approximately result from the actions by the defendants himself that they create a substantial contact with the forum. In other words, if the defendant initiated the contact with the forum, is that enough to have personal jurisdiction? And as far as the rule of law, there's several things that came out of this case. It addressed the reasonableness of the analysis here, that it balanced that, well, basically the fact that they made contact with the forum, it shows that they they subject themselves to that personal jurisdiction, and that it does say that in international due process protects an individual's liberty, but also it would be unfair. It's not like Shaker where they didn't initiate the contact, or like that case where the insurance company where they initiated the contact. So the second issue has to do with the fairness. So they were looking at the fairness issues, and there were several things that came out in this case. There were 6 things that they wanted to balance in order to see if there was fairness in the case. They didn't take all of these things into consideration with Birmingham, but it just set the tone for other cases to come. And those were the extent to which the defendant had a purposeful injection. So they did purposefully contact Birmingham because they wanted to set up a franchise. The burden on the defendant in defining the forum, and the Supreme Court did, when they spoke on their holding, they did talk about that burden of unfairness is relatively high. The standard for which they call something unfair is relatively high. They specifically said that a financial burden, it doesn't matter the financial prosperity of each of the defendant or of the plaintiff. They don't take that into consideration. They also extend to the extent to which conflict with the sovereignty forum. And when we think about the case with Jones, when they were in Florida, they basically insulted California, because in California, they actually had a statute protecting their citizens. So that's where the fairness is. The state's interest in adjudicating a dispute, the most effective judicial resolution for the controversy. That's sort of speaking to the fact that, let's say you have a child custody case and all children are in one state, or if you have a situation where all witnesses are in a state, that might be something speaking to the fairness as far as the resolution and the existence of an alternative forum. So basically, once it's been established, the defendant had been in minimal contacts is created, then it's unfair. It would be unfair to require them not to be there. Although this is presumably able to be rebutted based on the fairness issue, the question of fairness went against the defendant in this case, the Supreme Court when Birmingham appealed, and the Supreme Court basically ultimately said that the defendant from Michigan had to go to Florida, and Florida had personal jurisdiction over it.
Okay. In part because they agreed to have contact with the state of Florida by sending regular franchise payments.
So if you look at, I guess, number 1, where you voluntarily submitted, or there's consent, but not really, it's more specific, I suppose, jurisdiction, but it's not actually it's not the act that took place in Florida, but the injury took place in Florida.
Yeah, it is.
So would you say that it was forced?
Oh, I would say their conduct by signing a contract with Burger King that says you're going to have disputes here in Miami.
So you think that's more implied consent?
No, I think it's express consent saying we're going to resolve them in Miami.
Oh yeah, and that's just like the Carnival case that's coming up. It says on the ticket that it has to be.
Yeah, the Carnival case does say on the ticket, and in fact, MS Bremen versus Zapata says we're going to hear all our disputes in London. And the court said unless it's unfair to do it there, then they're going to honor the parties' agreement.
So that's why I was trying to figure out, like with the dissent, why there wasn't
They didn't have to sign the agreement with Burger King,
And
did
they
they?
could have lawyers look over the agreement if they wanted.
If Burger King had solicited them, would that be a little more?
If Burger King had reached out to them, then that would have been different. But these people actually went to Burger King because they saw an opportunity to make money. They just didn't realize their franchise payments would be so much. And they didn't manage the restaurant right, so they didn't make enough money to make the payments.
If you buy a franchise, then you know what you get.
Yeah, you're.
Really just talks about the unfairness. They didn't address, it didn't seem like they addressed, expressed themselves.
Yes, sir.
Yeah, I was going to hit on that, and people already hit on it. The court spent so much time on the unfairness and how one party can have an advantage, and they did talk about wealth isn't irrelevant to parties' wealth, but in this case, you had two individuals who obviously can't make the franchise fees, royalty fees and all that, so they're at a disadvantage right there. The court spent a lot of time on disadvantages compared to the other opponent, but then fell back to, they signed an agreement in Florida.
Right,
I was
so-
surprised how much time they spent on it.
So what do you call it when the court spends a whole lot of time on one thing and then doesn't end up using it in their decision?
Well, I said it,
Waste of time.
Waste of time, but they also call it dicta.
Dictum, yeah.
All right, dicta, D-I-C-T-A. All right, Asahi Metal, since we're running short on time, there was a Japanese manufacturer that made valve stems for tires, and they shipped those valve stems off to Taiwan to be manufactured onto a tire that made it onto a motorcycle that got shipped to California, where somebody promptly got on the motorcycle and wrecked, and then somebody brought a lawsuit because of the wreck, and they said the valve stem or whatever was defective. And in this case, the Supreme Court looked at this concept called stream of commerce. And in a stream of commerce, you have to put a product into the stream of commerce, and then the product has to be specifically directed to the foreign state. And in this particular case, the Japanese company did put a product, the valve stem, into the stream of commerce, but they had no clue that it was being shipped to California. And in that particular case, they said, no, you can't bring the Japanese manufacturer into court because they did not specifically direct their conduct toward the state of California. They directed it to Taiwan, where they put the motorcycles together. Next case, McIntyre Machinery versus Nicastro. Only 8 years ago, this company built a metal shredder, and they specifically directed their products toward the United States in general, not specifically New Jersey. One of them ended up in New Jersey, and somebody got injured from it. So they filed a lawsuit in New Jersey where the injury occurred. And the U.S. Supreme Court said, you have not shown where McIntyre has specifically directed the stream of commerce to New Jersey. You cannot rely specifically that it directed it toward the United States in general. You have to show where it was specifically to the state of New Jersey, and they held you cannot sue McIntyre there. Now, in McIntyre, the Supreme Court came up with a list. Sort of. It says a person may submit to a state's authority in a number of ways. There is, of course, explicit consent. We have consent already up on the board. Presence within a state at the time of suit commences through service of process is another example. Citizenship or domicilior, by analogy, incorporation or place of business for a corporation indicates general submission to a state's powers. And then it says, by contrast, those who live and operate primarily outside a state have a due process right not to be subjected to judgment in its courts as a general matter. Now on to Insurance Corporation of Ireland versus Campaign de Bauxite. In this particular case, this was a violation of a court order where the judge said, we're going to submit you to personal jurisdiction because you refused to obey a court order. In this case, this company said, you don't have personal jurisdiction over us. What you need to learn out of this case is the fact that the court can order discovery limited to whether or not there's personal jurisdiction. And in this case, they wanted the company to produce all of their business records dealing with that particular state, whether or not they've specifically directed their business toward that particular forum state. And they refused to obey a court order to provide discovery. So what the judge did says, if you refuse to obey this order, then I'm going to find that there's personal jurisdiction. And they said, go for it. And they refused to provide the discovery, so the judge did. Found personal jurisdiction. And they took it up on appeal saying there's no personal jurisdiction here. And the court actually ended up saying your refusal to cooperate in discovery to show that you're not subject to jurisdiction is enough to give court jurisdiction over you.
I understand that because they objected to the personal jurisdiction.
But they also refused to cooperate for the court to find out whether or not it really was a legitimate objection or not. And so refusal to obey a court order was grounds for the court to have jurisdiction over them anyway. That's one of them big exceptions that you just have to study and know about. Bristol Myers Squibb. Anybody want to try a 2-minute drill on this one? You've already done one. Ms. Ergus Rogers.
All right, so this case, the plaintiffs were residents of California and 33 other states. They brought a suit against Bristol Myers and asserted that a drug that they manufactured injured them. EMS was a Delaware corporation, which is the defendant, with a principal place in business in New York. Now, Plavix was not designed or developed or manufactured in California. The plaintiffs residing outside of California did not buy or take Plavix in California. The EMS moved to squash services summons on those plaintiffs who were not in California.
Quash.
Sorry. The Superior Court denied the motion. The California Court of Appeals held that California courts had specific jurisdiction over the non-residents' claims. The California Supreme Court affirmed finding specific jurisdiction because the claims and injuries of the residents were identical to those that were non-resident plaintiffs. The United States Supreme Court granted certiorari, and basically the issue was for a state court to assert specific jurisdiction, must there be an affiliation between the forum state and the specific claim at issue? Yes. For the state court to assert specific jurisdiction, there must be an affiliation between the forum state and the specific claim at issue.
Okay. So not enough contact violated due process. Thank you, ma'am. Now, the next case on our list is Mullane, I think. I'll do Mullane because it's just another trust case, and the actual outcome of it's not important for our lesson on personal jurisdiction, but other black letter law included in the opinion is. The court says many controversies have raged about the cryptic and abstract words of the Due Process Clause, but there can be no doubt that at a minimum they require the deprivation of life, liberty, or property by adjudication be preceded by notice and an opportunity for a hearing appropriate to the nature of the case. So due process requires notice and an opportunity for a hearing appropriate to the case. Personal service of written notice within the jurisdiction is the classic form of notice, always adequate in any type of proceeding. We've just discovered number 2. case y'all missed that, let me repeat it for you. Personal service of written notice within the jurisdiction. How did they get served? They got caught inside the jurisdiction, right? Is the classic form of notice always adequate in any type of proceeding? Always. Now, is there a defense to service inside of a jurisdiction? Yeah, if you fraudulently get them to come into the jurisdiction, there is. That's a defense. So we've got it as number 2 on our list, because if you consent, waive, or voluntarily submit, there's absolutely no argument. But if you're served inside the jurisdiction, the only argument you've got was that you were fraudulently induced to come into the jurisdiction. Otherwise, it is a traditional form of service that if you're caught inside the jurisdiction, you're subject to that jurisdiction. It would be idle to pretend that publication alone, as prescribed here, is reliable means of acquainting interested parties in a fact that their rights are before the courts. It's not an accident that the greater number of cases reaching the court on the question of adequacy of notice have been concerned on actions founded on process constructively served through local newspapers. Hello? Right? Because there's no personal jurisdiction, no in personam by newspapers. They have repeatedly held out. And there's one more quote I'm trying to get in here. Here's the exact quote that you need to know out of this case. An elementary and fundamental requirement of due process in any proceeding which is to be accorded finality is, here's your quote, notice reasonably calculated under all the circumstances to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections. Notice reasonably calculated under all the circumstances to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections. So here's an example for you. What if you've got a child custody case and you go to the Supreme Court saying, bless you, that you can't do it by publication, right? So what if the person that you're trying to give notice to of this case won't tell you their address? Do y'all think that actually happens? Won't give you their address. They have a Facebook account, but they've got the privacy settings set on it so you don't find out where they're posting from. You just see posts, and the posts come up every day. And every day they're showing you pictures of how they're smoking pot and holding a gun.
You can serve them on Facebook.
They talked about that last. Can you give them notice on Facebook about the pendency of the action? Can you convince a judge that it is reasonably calculated to give them actual notice of the pendency of the action? I know a judge who's done that. I know a judge who's allowed notice to be given by Facebook because under the circumstances it was reasonably calculated to give the person notice. And if they're on Facebook every day,
Yeah, what if it's not them?
oh well, if they're putting selfies of them smoking pot and holding guns, it has to be reasonably calculated under the circumstances. All right, so Mullane is important because it carves out notice reasonably calculated to give specific notice. Now, Jones v. Flowers. Y'all know what this case is about?
That's about the guy who paid the mortgage on his house, but he lived somewhere else, did not pay the property taxes. The tax collector of the state of Arkansas sent letters to his house to pay taxes out.
All right, we're real close on that about property taxes notice in Arkansas. You know who was involved in that? Because it was a nationwide thing. It was called Whitewater.
How about say this is Clinton?
And is it enough to post notice on the property if they know the owner lives somewhere else? No, because it's not reasonably calculated to give them actual notice. That's why you study Mullane, so you can argue not reasonably calculated.
They could have looked up his address through other means.
They probably could have. Now, Dusenberry versus United States, I think this was a forfeiture case where the FBI sent notice to his address, but they knew he was in prison because they put him there. Is notice going to be adequate if they send it to his address when they know he's not there? No. See how easy these are to go through? How about Young versus New Haven Advocate? All three of these cases deal with online. That's Young, Inset, and Zippo. Zippo was like the first case that spelled out the factors to consider internet. Young looked at how many people actually subscribed to the newspaper online and whether or not online activities can constitute enough, like the 10 to 15,000 subscriptions for Hustler magazine. And in some cases, if it's directed towards citizens of the state, it's enough. And if it's just a general web page that's not specifically directed towards citizens, it's not enough. Perkins versus Benguet Manufactured Consolidated Mining. This was a business doing mining out in the Pacific that during World War II relocated to Ohio, opened up a bank account in Ohio, did their business in Ohio, and yet when they got sued in Ohio, they said, well, wait a minute, we're actually a Pacific Island company. There's no jurisdiction over us here in Ohio. And the court said, crap, you've got a bank account, you're doing business, it's good enough. Daimler versus Baumann. What's important in this case is that a court may assert general jurisdiction over a foreign, whether or not it's a sister state or a foreign country, foreign corporations to hear any and all claims against them when their affiliations within the state are so continuous and systematic as to render them essentially at home in the forum state. So that's what you've got to reach the burden of. Systematic and continuous is essentially they have a home here. They are essentially residents of this state in order for that state to exercise personal jurisdiction over them. Schaefer versus Heitner. It's another shareholders action. Is in-rem jurisdiction subject to a minimum contacts analysis? Yes. Now, if the in-rem is a piece of property, does a piece of land that can't move have minimum contacts with the state? A piece of land that can't move? If the property this building is located on is in a lawsuit in rem to declare that I'm the owner instead of the school, does this piece of property have sufficient contacts with the state of Alabama?
Yes.
It always will. It doesn't move. But shareholder or shares of stock, that's where you get into the difficult part. Do the shares of stock have to have minimum contacts? And the answer is yes. Even shares of stock have to have minimum contacts. Burnham versus Superior Court. Funny story on that is they waited for the husband to come to California before they served him with the summons and complaint. He was caught inside the jurisdiction. Is that good service? Yes. It's number 2, personal service in the forum. And that's always going to be good. Carnival Cruise Line, they agreed to it. And Ruhrgas, RUHRGAS versus Marathon Oil. They don't have to look at personal jurisdiction. They don't have to look at subject matter jurisdiction before they look at personal. And then, which case did we cover where it was a resident was served outside the state? That's actually number 3. Yeah, I think that was flag. All right, so number 3 is residents of the state. If you are a resident of the state, you are always going to be subject to their jurisdiction. It doesn't matter if you're served in state or out. So let's look at this chart. Everything from number 3 down is going to deal with non-residents. And then residents is number 3. So if you're a resident, you're always subject. If you're not a resident, and you're not served in the forum, and you don't consent or waive, then you either have to have specific personal, whether you committed an act that caused an injury in the same state, you commit an act outside the state that causes an injury in state, or you commit an act outside the state causing an injury outside the state, where it's so completely unrelated to the state, but you still otherwise have sufficient minimum contacts so that you can drag somebody back into the state for something that happened somewhere else, for which Alabama has no interest at all in the case, for Alabama to hear your case. So look with me here. It doesn't matter whether or not you were served inside the state, where you live, where acts occurred. If you consent, waive, or voluntarily submit, the answer is no. Does it matter where you are served, or does it matter where you live if you're served inside the forum state? It doesn't matter. Does it matter where you are served if you are a resident of the state? So see, it goes from number 1 being the best down to they didn't volunteer, waive, or consent. And then they weren't served inside the state, but if they're a resident, it doesn't matter. And then you get down to where they're non-residents. Remember, it doesn't apply to plaintiffs. It only applies to residents or to defendants. So this entire chart is only on defendants. And if they're not a resident, if they commit an act here that results in an injury here, you got them. But you got them under Hess. If they commit an act outside the state that results in an injury here, you've got them specific personal, but that's called their effects. If they commit an act outside the state that results in injury outside the state, then that's the most attenuated argument you can make on personal jurisdiction. And the only way that you can get them here is if they otherwise have sufficient systematic and continuous contact such that they are, I'm going to use the term, constructively present in the state versus actual presence. Constructive, they're technically at home in the state, even though they're not. They're not literally at home in the state. So if you've got a choice of any of these 6 types, you want to use the argument that's the best. So you take the higher one up on the chart. If you've got a fact pattern that says a non-resident defendant who shoots a gun at the state line of Georgia that hits somebody in the state of Alabama is served with a summons and complaint in Alabama, to which they file an answer without raising an objection to personal jurisdiction, your best argument for personal jurisdiction is that they waived it. But if they do raise an objection, what's your next best argument? That they were served inside the state, right? But if it wasn't really them that was served inside the state, but it was their relative, then it's Calder, right? Because they shot the gun at the state line that hit somebody in Alabama. So you see how the facts can really turn real fast. But the better the argument you've got, the higher up on the chart you have, the more confident that the court's going to be that they have personal jurisdiction over you. That's how to keep them in court. you think about this before you file a suit, because you got to anticipate they're going to object to personal jurisdiction. Because if they can win that, even before subject matter jurisdiction, they're automatically out of the case. So you've got to anticipate one of these. How do you do it? You got to figure out how you're going to get them served, right? You've got to think about where they live. If they're a resident, doesn't matter where you serve them. If you can catch them inside the state, it doesn't matter that they don't live here. Or if they've committed an act that resulted in an injury here inside the state, you don't even have to worry about serving them inside the state or where they live. Those are the factors you got to consider to keep them in court. As long as you've got one above number 6, you've got a good argument. If you have to resort to number 6, you're desperate. And then you've got to start coming up with what kinds of contacts do they have with the state. One of which is, do they have a bank account that's been opened up here? Do they get mail here? Because if you get mail here, aren't you essentially a resident? Can you make that argument? Who put the forwarding order in? All right, anybody that came in after I called roll, please come see me and get on the list. That's because you have to turn in this summary and tell me where your cases go.
Say it again now? Wait, can you repeat that?
Just put the case side. Like, I put Tess up here already. I put Calder here. Most of the cases from here.
So you don't necessarily know all of our briefs. You want to know which particular case. Yep, ready? And then